Hello, 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 everybody. Hello, welcome. Welcome, hello. Little bonus live for you today over here on the talk. I am still planning to be over on the tube tonight, everyone. But I thought I would pop over here and do a little bit over the lunch hour here. So welcome in. All right, Department of Homeland Security, here we go. And this is the South Sudan group, just so we can keep all of our groups of people. Oh, hello, hello. Hi, Duchess. Hello, Nancy. Hello, Nani. Thank you so much. Nikki, hello, hello. Strano, Strano. Good to see you. Thanks for joining, everybody. This is quite the case here. This is, my goodness gracious, quite the case. So this is a class certified case. It's class certified. And we have the plaintiff's claim for no third country. That's what the lawsuit's about here. So if you want to do a deportation, that's fine, but let's not just do random countries, shall we? Oh, good, Mincy. I'm glad to hear it. Oh, I'm glad to hear it. Yeah. So this order came out yesterday, everybody. Oh my gosh, I'm sorry. That's my cat. Pearl. I'm so sorry, everybody. that was my cat. That did you hear her? Sorry, everyone. Sorry. All right. She's quite the squeaker. Yes. Hello, Pearl. Oh my gosh. Yes. She when she gets the zoomies, sometimes she gets a little extra chatty. So. All right. Well, welcome in. So when last we met, hello, Jennifer. Welcome. When last we met, everyone, on the DVD case, this is, again, the lawsuit where the plaintiffs are saying, again, deportation, fine, but not just a random third country. So we're suing so that you can't just send us to another country. Now, so far in this case, we have had a preliminary injunction put into place by the judge, and we had 6 people who had been sent over to South Sudan and without proper due process. And of course, our due process procedures will depend. It's case by case what exactly will constitute due process. But in this case, we have due process violations going on. The judge in this case, so Judge Murphy, has already found violations of the preliminary injunction by the government. That's already been found. He then also gave an order on Friday explaining to them how they could kind of cure that mistake that they made. So how could they fix it or mitigate the damages that they had done with these 6 people? And he set out how to do it. So the defendants, the government here, then filed a motion to stay and a motion for reconsideration, and setting out not a lot of information. Actually, it was pretty light, where they just said we disagree. That's really it. Not a lot of legal arguments there. And I also did have a chance here. Thank you, everyone, for your hard work. So just to keep in mind here when we're talking about the defendants, let me show you. First of all, this is, oh my gosh. Seriously, there's a filter on, everybody. I'm sorry. Wait, is there a filter? There is. Look at those eyebrows. Oh my goodness. Sorry about that. I try to turn the filters off, everybody. Here we go. All right. So here's which filter's even on there? Oh my gosh, the smoky eye. All right, so this is the Yakov fella. This is the assistant attorney general fella who has been involved in these cases. All right, so he's done some filings that I think would absolutely rise to the level of bar complaints for sure. So he's kind of like the point person, this Yakov fella here. And then the other one in this case to really look at, we'll go ahead and take a look at the JD filter. Here's another person here. This is Eric MacArthur. Or, oh, again, with the brows, everybody. I take the time to pull the filters off before I go live. So this is like, what's happening? All right, so this is the Eric MacArthur person. This is Eric Hamilton. So we've got two Erics here. This is more of like a Mr. Clean style person. And then we have Drew Ensign. This fella right here, this one, he's done a lot of damage, this particular person. So this fella is also who we're talking about. And then over here we have a Jonathan Guyon, I guess here. Gwyn, Jonathan Guyon. I don't know. I'm not great with pronunciation. So here's the other one. All right. So we've got, and he's more in the torts situation, but these are kind of the top dogs, that are in these cases involving all of this. All right. So Gyno, is that right? Well, there's no O. Gynon. All right. Maybe. Yeah, that works. All right. So sorry about the filter, everybody. I promise you, I had tried to take it off before we started. Don't need a filter for the hands. All right, so again, and just to keep in mind, this is probably the number one here. We've got, Bondi is the first person, right? And then we have the, who's that other guy that got yelled at by the New York judge? What was his name again? Oh my gosh, I forgot his name. He's also, what was his name? Hold on, I gotta think of it or else it's gonna drive me crazy. It starts with an E. What was it? And the judge was like, have you ever been in court before? What are you doing? What's wrong with you? No, he was, Bovee. Thank you, VC. Oh my gosh, VC, thank you. So yeah, Bovee, so Bovee, right, is that kind of second, number two, but this guy is like number one for these cases here. All right, so just keep that in mind because the judge is going to dive right in and has some stuff to say about the defendants. All right, so I wanted to keep that in mind. So this is his real picture. I apologize, there's a filter on it. So those are not his real eyebrows, I don't think. But I know, I'm sorry about that. So this fella here, and then the other one to kind of keep your eye on is this fella here, this Drew Ensign guy, or Ensigan. Anyway, whatever. This is the other fella. All right. So keep those guys in your mind as we go through and we learn about the defendants here who are really, the judge is pretty upset about it. So, yes, the eyeliner. I know it was a lot. Sorry. On scene, ensign. All right. Well, whatever, everybody. I'm sorry. Oh my gosh. Just give me flashbacks to my labor law professor who gave me a hard time about names. He's the only professor that ever gave me a really hard time. Anyway, all right. So here we go. We have an order again that came out just yesterday. This is the judge's response to the defendant's motion for reconsideration regarding the preliminary injunction and the rules that the judge set out regarding specifically those 6 people who had been sent over to South Sudan. Now, I will be the first person to tell you those 6 people are literally criminals. I mean, they literally have criminal records. They have a bad history, those 6 people. So as we go through this, I'm not going to try to say, oh, let's feel bad for them. No, I don't have any bad feelings about that. But we do have a constitution. And even if you're a bad person, because I'm a good person, I follow the Constitution. So we got to kind of remember that as we go. All right, so let's go ahead and dive in. And right here, again, this was just yesterday. So Judge Murphy, defendants have mischaracterized this court's order. That is a terrible way to start. This judge is upset. The very first words, defendants have mischaracterized this court's order, while at the same time manufacturing the very chaos they decry. By racing to get 6 class members onto a plane to unstable South Sudan, clearly in breach of the law, and this court's order, defendants gave this court no choice but to find that they were in violation of the preliminary injunction. So we're on fire here. This judge is super upset. Even after finding that violation, however, the court stayed its hand and did not require defendants to bring the individuals back to the United States as requested by plaintiffs. Instead, the court accepted defendants' own suggestion that they be allowed to keep the individuals out of the country and finish their process abroad. In the interest of full transparency, the court quotes at length from the hearing transcripts, which we love that for us. All right, oh my gosh, we have transcripts, everyone. So here we go. Oh my goodness gracious. Here we go. Here's the court to plaintiff's counsel. Plaintiff's counsel is suggesting that the only remedy is for the plane to return here so that these individuals be given an opportunity to raise any objections they have to being sent to South Sudan. Do you have another suggestion as to what a remedy that would allow these people to have process that they are due might be? And Mr. Government says, if I may, we think any remedy should be narrowly tailored to the violation. And so, if Your Honor believes they weren't given a meaningful opportunity to express a fear under CAT, that the remedy should first be limited to giving them such a meaningful opportunity. If they were to do so, then they would be given that reasonable fear interview. But bringing them back would be a much broader remedy than necessary because this court only requires compliance with procedures. And to that extent, Your Honor believes, those procedures were not followed, the government should be allowed to provide those procedures, and that should satisfy the due process as interpreted by the court. Court's response, thank you, Mr. Ensign. So let's say that I agree with you, that I want to make the most narrowly tailored order to address the violation of my preliminary injunction that's possible. What you're suggesting is that they can have a reasonable fear interview where they are now. Is that a practical possibility? Government's response, Your Honor, I don't know. I'd have to speak to my client. But I think that would need to be at least one of the compliance options that's presented, because that would be a much more narrowly tailored remedy that is actually tailored to the violation that Your Honor has found. Footnote number 1 is a citation to the transcript. After this exchange, defendants spent several hours conferring internally as to the feasibility of this option, ultimately deciding that it was doable. Again, another footnote here, number 2, the quotes from the court here. I'm very much considering this, but if this is the route we go, my inclination would be to say, if you want to do all of these interviews where they are, you have to do them appropriately. If you don't want to, you can always bring them home of your own volition and do it there. And so I'm not going to mandate that the department do anything overseas, but in an effort to craft as circumscribed a remedy as possible, I'm inclined to say if the department wants to figure that out, I'm inclined to let them. Right? So again, we went through what the judge's order was, and he was very specific. He said, here are 7 factors, and you need to do these 7 factors. If they're here or not here, that's not going to be relevant. And then the government responds, and we appreciate that, Your Honor. And to the extent that it poses challenges that would be insurmountable, we would quickly inform the court and use one of the options to comply with the court's order. And then footnote number 3 again is a citation to the transcript. All right, so that was the exchange back and forth between the court and the government. Since that hearing merely 5 days ago, defendants have changed their tune. It turns out that having immigration proceedings on another continent is harder and more logistically cumbersome than defendants anticipated. However, the court never said the defendants had to convert their foreign military base into an immigration facility. It only left that as an option. Again, at defendants' request. The other option, of course, has always been to simply return the status quo of roughly 1 week ago, or else choose any other location to complete the required process. Oh my gosh. Hello, Thomas. Oh my goodness. To be clear, the court recognizes that the class members at issue here have criminal histories, but that does not change due process. Quote, the history of American freedom is in no small measure the history of procedure, end quote. Quote, it is procedure that spells much of the difference between the rule of law and the rule by whim or caprice. Steadfast adherence to strict procedural safeguards is our main assurance that there will be equal justice under the law. Citing 1951, and this is a great case actually. The court treats its obligation to these principles with the seriousness that anyone committed to the rule of law should understand, including lawyers. It continues to be this court's sincere hope that reason can get the better rhetoric. The orders put in place here are sensible and conservative. Accordingly, and for the reasons stated herein, defendants' motions for reconsideration and for stay pending appeal are denied. All right, so we're not going to hide the lead. And next up is our background here. Again, this is just yesterday this decision came out. General background. This action concerns the procedures that the government must take before removing non-citizens to third countries. The Immigration and Nationality Act, 8 U.S. Code Section 1101, determines the country or countries to which an individual can be removed. In the first instance, the government generally must remove a non-citizen to their country of origin or to the country designated on their order of removal. If those options prove impracticable, inadvisable, or impossible, the government may remove the non-citizen to any other country whose government will accept them. The government's power to designate third country for removal is subject to certain limitations by Congress. In particular, the government may not remove a non-citizen to a country where they're likely to be tea orchard. Thank you, VC. And then let me clarify this tea orchard situation. This is every time I talk about CAT, which again is a treaty with the United Nations. What happened was, here's the treaty, and then we codified it. We put it actually into our federal statute and referred to it here. So both CAT and FARA, are the same thing, all right? A non-citizen's claim that he or she qualifies for this type of protection is called a CAT claim, referring to the Convention Against Tea Orchard, an international agreement implemented by Congress through FARA. Case background. On March 23rd of 2025, plaintiffs filed this action claiming defendants were removing people to third countries without giving an opportunity to show that they were at risk of persecution or tea orchard. On April 18th of 2025, the court issued a preliminary injunction which required defendants to tell class members about their third country removals in advance and to give them meaningful opportunity to show or explain why they qualify for CAT protection. Hopefully I'm in frame okay here, everyone. Let me know if I need to bump the frame up a little bit. I might just pull it up just a tad here just to make sure. Okay. Twice, oops, here we go. I flipped the wrong page. Back again. Okay. Twice, well-founded allegations of noncompliance or imminent noncompliance led this court to amend or clarify the preliminary injunction. Neither of those changed the substance of the preliminary injunction, which continued to require defendants to give written notice to the third country removal and a meaningful opportunity to make a CAT claim. Looks good. Okay, thank you so much. I appreciate that. Present issues. On May 21st of 2025, plaintiffs again moved for a temporary restraining order and preliminary injunction, alleging that defendants were violating or had already violated the preliminary injunction by removing an unknown number of individuals to South Sudan without advance notice and without an opportunity to demonstrate CAT eligibility. Again, this is an international agreement. Shortly thereafter, the court called a hearing by remote video conference. Defendants' attorneys had very little information, and the court ordered defendants to maintain custody of the individuals while everybody figured out what was happening. The court held an in-person hearing the next day, May 21st. An hour prior, defendants held a press conference where they revealed the names and criminal histories of the individuals on the plane. Whoa, at least 6 of whom turned out to be class member plaintiffs in this case. Whoa. All right, we've got a citation here to that press conference. At the hearing, the court learned that these individuals were being held at a foreign military base in Djibouti. And then we have 5 here. Defendants requested that the country location of the individuals be kept under seal, but have since made that information public. Oh my gosh. The court heard sworn testimony from the ICE Acting Assistant Director for Field Operations and Enforcement and Removal Operations, Marcos Charles, and Acting General Counsel of Department of Homeland Security, Joseph Mazzara. Based on the testimony, plaintiff submissions, and defendant submissions in connection with the instant motion, the court has made factual findings substantially reflecting its understanding of the events immediately following the May 21st hearing. So just so you know, this is moving quite a bit faster than the JGG case in DC was, just FYI. Sometime on May 19th, defendants informed 8 individuals in ICE detention that they were being removed to South Africa. Later that day, no earlier than 5:46 p.m., defendants told them instead they were being removed to South Sudan. Again, we've got footnote 6 here. All refused to sign their notices of removal. The U.S. government has issued stark warnings regarding South Sudan, advising its citizens not to travel to there because of crime, kidnapping, and armed conflict. The U.S. Department of State further warns that, quote, violent crimes such as carjacking, shootings, ambushes, assaults, robberies, and kidnappings are common throughout South Sudan, including in its capital, Juba. I apologize, everyone. Foreign nationals have been the victim of SAs and robberies and other violent crimes. The following day, no later than 9:35 a.m., the class members left detention and were brought to a nearby airport. Footnote 7 says one attorney was told by ICE at 8:27 a.m. that her client had already been removed. After leaving the detention center, class members definitively had no communication access. Thus, these individuals received fewer than 16 hours notice before being removed, most of which were non-waking hours, none within the business day. During the interim, they had limited, if any, ability to communicate with family or legal representatives, and little, if any, opportunity to access information that would have allowed them to determine for themselves the repercussions of being removed to South Sudan. The plane was in the air by noon. And then we have footnote 8 here, bumping down. And it says Acting Director Charles testified that detainees generally have access to a telephone or a tablet for communication purposes while in custody. However, he could not confirm whether these specific individuals did or at what time their access was cut off. As stated, at least one attorney attempted, but was unable to meet with her client during the short window. All right, that was footnote 8. Based on this information, the court found the defendants had violated the preliminary injunction and crafted a remedy based on defendants' requests made during the hearing. So we do have a violation, so that's our contempt. And then footnote number 9 Defendants characterize docket 118 as an order. The court believes it is more properly a clarification, but need not muddy the waters. So again, this is the order in which they found he had found the violation. The court further issued clarification as to the preliminary injunction based on the defendant's representation that the initial iteration of the preliminary injunction wasn't specific enough. Quote, I just want to highlight, Your Honor, that I think that part of any misunderstanding from the Department of Homeland Security may have had to do with the fact that the court's preliminary injunction motion wasn't specific enough. And so we asked the court, please take that into consideration when issuing its order, end quote. Procedural posture. On May 23rd at 9:03 p.m., defendants moved the court to reconsider its finding that defendants had violated the preliminary injunction and to vacate its orders accordingly. And then footnote 10 here, defendants characterize docket 118 as an order. The court believes it's more properly a clarification again. So I think I had the wrong footnote earlier. Let's keep moving. We'll keep the bus moving here. Footnote 10 versus footnote 9 here. In the alternative, defendants seek a stay of those orders pending appeal. The removals at issue were brought to this court's attention originally via plaintiff's May 20th motion for a temporary restraining order and preliminary injunction. Had the court not found the defendant's actions were already covered by the preliminary injunction, it would have issued the same remedy in the form of a new temporary restraining order or preliminary injunction. In other words, the court believes that it already ruled prospectively that defendants' May 20th actions were unlawful. But even if not, the court would find them unlawful now to the same effect. Accordingly, the court will supplement its analysis to address those factors as necessary below. All right, so the court's being very clear. We have violations of the court order. Next, what we're going to see as we go through this piece is the judge is setting this up for appeal. So as he's going through and explaining everything, he has in his mind what the U.S. Supreme Court is going to see. So I have no doubt about it. All right, legal standard. Whoops, got to get my tang. Sorry, everybody. All right, there we go. Legal standard, motion for reconsideration. A district court has the inherent power to reconsider its interlocutory orders. Interlocutory just means that these are appeals and cases that are being brought up before the end of the case. All right, that's what interlocutory means. A motion for reconsideration is allowed where the original decision was based on a manifest error of law or was clearly unjust. Sorry, everybody, I've got to get a throat lozenge here. I apologize. All right. Citing the Allen case, however, unless the court has misapprehended some material fact or point of law, a motion for reconsideration is normally not a promising vehicle for revisiting a party's case and re-arguing those theories previously advanced and rejected. So motion for reconsideration was the vehicle they used. Next, motion for stay pending appeal. Deciding a motion for a stay pending appeal requires an exercise of the court's equitable discretion. Here, the court considers the following factors, substantially like those considered on a motion for a preliminary injunction, right? So these are similar to the Winter factors. Number one, whether the stay applicant has made a strong showing that he's likely to succeed on merits. Number two, whether the applicant will be irreparably injured absent a stay. Number three, whether issuance of the stay will substantially injure the other parties interested in the proceeding. And four, where the public interest lies. Yeah, likelihood of success is the essential element. And that's the Acevedo Garcia case out of 2002, calling the sine qua non, my Latin's even worse than my English, for a state pending appeal. C, motion for temporary restraining order or preliminary injunction, which again is this question in front of the court right now on the birthright citizenship cases. A plaintiff seeking a preliminary injunction must establish that he's likely to succeed on the merits and that he's likely to suffer irreparable harm in the absence of preliminary relief that the balance of equity tips in his favor and that an injunction is in the public interest, citing case law here. And then they're quoting the winter factors, which we've kind of gone over before. Sine qua non. Okay, sine qua non. That definitely sounds better. The last two factors merge in a case like this one, where the government is the party opposing the preliminary injunction. Likelihood of success weighs most heavily on the preliminary injunction analysis. The standard for issuing a TRO is the same as for a preliminary injunction. Discussion. A. Motion for reconsideration. 1. Defendants violated the preliminary injunction. So this judge isn't even playing around. It's just that simple. We have finding of contempt, all right? Violation of the order. But how that goes forward, we'll have to see. Defendants characterized this last week's event as a big misunderstanding brought on by the court's failure to specify what constitutes a, quote, meaningful opportunity, end quote, to present fear-based claims. Indeed, at the March 28th hearing, defendants' counsel did raise the issue and, by way of example, pointed out defendants would likely consider the opportunity plaintiff OCG received to have been meaningful. I've done a couple of posts on OCG, which is absolutely heartbreaking case. Defendants now argue that the parties in the court were essentially on notice that defendants might apply that same standard prospectively as a way of complying with the preliminary injunction. The fatal flaw with this argument is that prior to May 20th, the court had already twice found OCG's process was likely insufficient. And then we have footnote 11 here. At those times, the court declined to order OCG's return based on defendants' then assertion that OCG disavowed any fear of his removal. That factual dispute has since been resolved in OCG's favor, and the court has accordingly ordered defendants to facilitate his return. Moreover, as March 28th, defendants were claiming that OCG was notified of his removal in January, roughly 3 weeks prior to his actual removal in February. Footnote 12 here. Defendant's brief states OCG was asked whether he had a fear of being sent to Mexico in January. The declaration cited that OCG's removal was scheduled on or about January 31st, and that OCG was asked whether he had a fear of being sent to Mexico on or around February 21st, the day of his removal. While inconsistent either way, a natural reading is that OCG was at least notified of his removal time scheduled. Yes, lots of sighs. It's therefore impossible to justify defendant's position that OCG's case reasonably stood as a benchmark of compliance with the due process protections this court has determined to be required. Defendants effectively tell this court that it should have at least tried to micromanage the Department of Homeland Security as it fulfills its required obligations, but that is not the role of the courts. Citing the Martinez v. Bondi case, explaining that the appropriate remedy for improper agency action, quote, except in rare circumstances, is to remand to the agency for additional investigation or explanation, end quote. Rather, this court has strived to give defendants as much flexibility as possible within legal bounds. At the end of March 28th hearing, the court presented defendants with a good faith opportunity to define the process provided under the preliminary injunction. And then we have a court transcript. So this is from the bench. In the meantime, I take your point about the court ordering what meaningful means to heart. And so I would consider a motion to reconsider if you wanted to narrow what the procedure looks like, or you wanted to come to an agreement about what it looked like, or you wanted to tell me this is what we're defining as meaningful, and I would like you to reconsider and adopt this. I'm open to all of those things because you raise a very good point. And so, to the extent that the guidance that the court is giving you is nothing more than a meaningful opportunity, and you want some more direction, or you want to narrow that with some more specificity, I would welcome a motion to consider. So the judge is saying, well, why don't you tell me what these words mean to you? If you file a motion to consider, I can hear you. I think you're in DC, so I can hear you, even by Zoom within 24 hours. And then there's a citation to the transcripts. Defendant's counsel thanked the court for the opportunity, but then declined to take it. Footnote 13. Defendants moved for an indicative ruling as to whether the court would find that subsequent guidance issued by the Department of Homeland Security mooted plaintiff's claim. Ooh, that's not good. That guidance did not address or attempt to clarify the substance of what constitutes a meaningful opportunity. Indeed, its thrust was that in certain circumstances where the United States has received diplomatic assurances, no opportunity would be had at all. All right. And then we're still quoting out of the transcript, finding that the procedures outlined in the guidance were insufficient. For the remainder, defendants offered no clarity as to what opportunity they would propose as acceptable. So they're saying, the judge is saying, like, look, I told you to tell me what this means, and they did not. So that's the issue here, right? The judge is like, fine, you don't like my definition? Well, let's use yours. What's your definition? And they did not tell him. Consistent with this approach, the court has repeatedly asked defendants to weigh in on the particulars of its remedies, and defendants have consistently refused. Quote, the court has been forced to decide on an appropriate time limit because defendants were unable, unwilling, or incapable of meaningfully engaging in a discussion about what process was required to provide aliens with a meaningful opportunity to contest a finding that their fear was reasonable. Wow, that's a lot of that's some anger there. Even in this latest round of back and forth, nearly 2 months later, the court again asked defendants for input on the appropriate length of time to raise a fear-based claim. Defendants again refused to engage. Footnote 14. Tellingly, defendants still do not propose any suggestion for how to define what constitutes a meaningful opportunity. Defendants say the court did not heed the government's warning. Whoa. All right, we're backing up here. This looks really bad. Defendants say that the court did not heed the government's warning that it should be allowed to draft a proposal for the court's review. That's incorrect. The court expressly welcomes such a proposal. The government did not submit any proposal. Wow. That's not a good look. And then we're back in here into the transcripts. Oh, where's my pen from? This is an Etsy store. I will just make a note and show everyone here at the end. Oh, real quick. This is the place, everyone. If you're interested, I've had several people asking about that. So there you go, screenshot, you're welcome. All right, Mr. Ensign, certainly our position is that 24 hours is sufficient. We recognize you disagree, but we don't have a specific proposal in light of this court's disagreement with the position. Footnote 15 says, of course, the individuals here had fewer than 24 hours. They had at most 16. The court then suggested that defendants could provide additional authority after the hearing. Defendants did not. From this course of conduct, it's hard to come to any conclusion other than defendants invite lack of clarity as a means of evasion. Ooh, that's pretty harsh. Let's put a little star by that. You don't want to have a judge say that to you. Like, the only reason you don't understand what I'm saying is because that's part of your plan. Defendants' arguments might be stronger if this were at all close, but the court breaks no new ground in finding that the events of May 20th did not include a meaningful opportunity for the class members to present fear-based claims. Defendants' own submission shows that it is ICE's general practice to provide 24 hours notice prior to removal. Here, the class members had fewer than 24 hours notice and 0 business hours notice before being put on a plane to South Sudan. Class members appear not to have had any access to counsel. Indeed, a declaration submitted by plaintiffs alleges that ICE canceled at least one attorney's pre-scheduled meeting with her client. Number 17 here. One attorney states that at 8:27 a.m., she was informed that her client had already been removed to South Sudan. Defendants claim that the class members did not leave detention until 9:35. Ooh, that's sketchy. That's not good. Class members likewise had no opportunity to learn anything about South Sudan, a nascent, unstable country to which the United States has recently told its citizens not to travel because of crime, kidnapping, and armed conflict. And then that's a citation. The court notes that class members were flown out on chartered flights, which defendants state can take 30 days or more to coordinate. Ooh, we gotta highlight that one. Ooh, that's not good. That's really, oh my gosh, that looks really bad. That is, oh my gosh. All right, we're building a case, everybody. We got to get this ready. We would just need to get the person to come in and testify. So how long does it take for you to coordinate something like this? Minimum 30 days. Oh my goodness. Then the court's left to consider, why were these individuals told less than 16 hours in advance? Citing case law, an elementary and fundamental requirement of due process in any proceeding, which is to be accorded finality, is notice reasonably calculated under all circumstances to apply interested parties of the pendency of the action and afford them an opportunity to present their objection. That's out of the AARP case, which we've talked about many times. Under these circumstances, notice roughly 24 hours before removal, devoid of information about how to exercise due process rights to contest that removal, surely does not pass muster. Given the totality of the circumstances, it's hard to take seriously the idea that defendants intended these individuals to have any real opportunity to make a valid claim. Now we've got an intent element. Well, that's not good for the defendants. Defendants' comparison to expedited removal is a red herring. Oh dear. Not the red herring. All right, so footnote 19. It also goes more towards the merits of the case than the question of whether defendants violated the preliminary injunction. Nevertheless, the court addresses the argument insofar as it informs what a reasonable person could understand a meaningful opportunity to be, and insofar as it bears on the court's findings in the alternative regarding plaintiff's motion for preliminary relief. Plaintiff's class excludes non-citizens removed pursuant to expedited removal, citing the order defining the class to include individuals who have a final removal order issued in proceedings under Section 240, 241A5, 238B of the INA. Expedited removal usually involves individuals apprehended at or near the border, or who are denied admission at ports of entry before due process rights attach. By contrast, CAT claims emerging from standard removal proceedings, reinstatements of prior removal orders, and administrative removals have greater protections, including judicial review. And then we've got footnote 20 here. The court notes, as have scholars in this area of the law, that it is somewhat of an anomaly that reinstated removal orders are subject to judicial review, while expedited removal orders, which may form the basis of reinstatement, are not. That's a good point. That's interesting. Nevertheless, that's how it works. Oh, this judge, the comparison is thus in opposites. We'll bump down here to footnote 21. Even applying the law of expedited removals, however, the events of May 20th would have been unlawful. On May 9th, the District Court for the District of Columbia struck down the final agency rule that required non-citizens to affirmatively manifest fear of their return or removal in order to be given a fear screening interview, as opposed to the previous rule, which required officials to provide individual advisals to each non-citizen and affirmatively ask questions designed to determine if the non-citizen qualifies for a credible fear interview. Again, everyone, the fear interview, you may ask, well, why do we have to do that? Again, it's because of the international treaty that we've signed. By defendant's own admission, these class members were not affirmatively asked any questions regarding their fear removal. Accordingly, insofar as defendants contend that the law of expedited removals informed their understanding of what constitutes a meaningful opportunity, that analogy fails them on its face. Wow. All right, and we're almost just a couple of pages left here before we get into the court's order. I know, yeah. Site check it. Oh, absolutely. I do that a lot. I have to. Not so much with the judges, but absolutely for the defendants. The court's remedy was flexible and narrow. Despite defendants' contention to the contrary, this court has never directed the executive branch to conduct foreign relations in a particular way or engage with a foreign sovereign in a given manner. Rather, this court's order remedying defendants' flagrant violation of the preliminary injunction merely outlines the procedural rights owed to class members and grants defendants full flexibility about how and where it can accomplish that. DHS, in its discretion, may elect to provide this process to the 6 individuals, either within the United States, should it choose to return them to the United States, or abroad, if at all relevant times DHS retains custody and control over the individuals in conditions commensurate to those the individuals would have been housed in were they still in DHS's custody within the United States. That's another big question, of course. We have no idea what's going on in South Sudan. It cannot be said enough that this is the results defendants asked for. Citing the transcripts, quote, I think we certainly agree that any remedy should be narrowly tailored. I don't know that return to the United States would be required to carry those interviews out. I think that those could potentially be conducted abroad. This court sought to fashion a remedy to address the constitutionally inadequate nature of the class members' removal, while not limiting defendants' ability to effectuate those removals in the most expeditious manner possible, subject, of course, to constitutional requirements. In doing so, the court offered defendants a method of compliance that both guaranteed the procedural rights, due process to class members, but was less exacting than having to turn around a chartered plane. The court considered defendants' prerogative in the sensitive and political areas of immigration and foreign policy and offered defendants complete discretion to provide these interviews in a time and manner they deemed best. Defendants described the hardship of having to carry out impromptu immigration proceedings on foreign soil, but that was and continues to be defendants' daily choice. Quote, to say more would be to paint the lily. Oh, goodness. All right, motion for a stay pending appeal. And here's our last little piece. As a threshold matter, the court finds this request for a stay perplexing. Oh, wow. All right, everyone. So a stay means that the proceedings in the district court would be paused until the Court of Appeals makes their decision. All right. So they're asking him to pause everything. And instead of saying yes or no, he's saying, well, that's interesting. The order remedying defendant's violation of the preliminary injunction is as flexible as possible, leaving the details of when, where, and how entirely in defendant's hands. Quoting that order, each of the 6 individuals must be given a reasonable fear interview. DHS, in its discretion, may elect to provide this process to the 6 individuals, either within the United States, should it choose to return them to the United States, or abroad. It is the narrow remedy defendants requested. And then this is just a citation there. In short, there is very little to say absent completely blessing defendants' violation. Oh my goodness. All right, this is what we call, legal term is called some sass. Oh my gosh. As to the clarification of to the preliminary injunction that addresses a problem raised by defendants, quote, the court's preliminary injunction wasn't specific enough, end quote. I think the judge is mad about that. Defendants asked this court to reverse its clarification, but offered nothing to put in its place that would do little more than return us to the same spot as before. As to the request itself, for the reasons stated on the record and further outlined in document 118 and in section A, defendants have not made a strong showing that they are likely to succeed in demonstrating that there was no violation of the preliminary injunction or in challenging the appropriateness of the court's relief. Accordingly, defendant's motion for stay pending appeal is denied. Motion for temporary restraining order or preliminary injunction. In the alternative, the court finds that it would grant plaintiff's motion for a temporary restraining order or preliminary injunction. Okay, hold on a minute. There's already a preliminary injunction in place with actually 3 orders clarifying it. So it would, keep that in mind. Likelihood of success and irreparable harm clearly weigh in plaintiff's favor, although defendants raise serious concerns regarding the public interest, which justify the court's limited remedy. Likelihood of success, for the reasons stated on the record and further outlined in 118 in Section A, the court finds plaintiffs are likely to succeed in showing that the May 20th attempted removals were unlawful. Irreparable harm, the court further finds that this class members at issue and continue to be at risk of irreparable harm in the absence of injunctive relief. The court has already outlined the risk factors by class members generally. Here, that risk becomes tangible as class members were nearly dropped off in a war-torn country where the government states that foreign nationals have been the victim of SAs, robberies, and other violent crimes. Whoa. Footnote 24. Here, the court notes an additional reason to deny this motion. If it's in a footnote, everybody. Stays are tools of equity. Yeah. And they are thus subject to equitable doctrines. Here, the unclean hands doctrine bars equitable relief. Whoa. Oh my gosh. Yikes. Oh my gosh. This is the bad faith element that we've been talking about, where our Department of Justice is acting so much in bad faith repeatedly. Yikes. He who comes into equity must come with clean hands. Discretion cautions against granting preliminary, extraordinary relief where a party has, at best, sought to get around an injunction through clever compliance. Wow. That's a huge hit. That's a huge hit to the government. Wow. All right, balance of equities and public interest. Defendants' last set out arguments, when stripped of rhetoric, sound primarily in the public interest and in the hardship that the government faces in complying with Congress's immigration laws. It is so. The laws, shucks. This court shares defendants' concern about the limited role courts should play in directing the executive branch and continues to be open to a solution for how to craft narrow and effective relief. This court has also taken into consideration defendants' determination that the class members at issue pose a security threat and has withheld action accordingly. For example, against plaintiff's request, the court did not dictate the terms of the class members' detention, respecting safety concerns raised by defendants. Likewise, the court did not order the class members returned to the United States, and otherwise gave defendants remarkable flexibility with minimal oversight. All of this to say that the court has reviewed the totality of the situation, including the criminal histories of the individuals and the undoubted operational costs, and has weighed those factors in ordering as narrow relief as the Constitution will tolerate. Conclusion. For the foregoing reasons, defendant's motion for reconsideration and for stay pending appeal are denied, so ordered. Judge Murphy. Oh my gosh, everybody. This is on fire. Goodness gracious. That's something else. Zero interest in playing games. You're correct. Yeah, this judge is not even playing around. So found multiple places stated that the government violated the preliminary injunction, and then set out how multiple times. And then set out multiple times that the government was acting in bad faith, trying to get around the injunction, trying to figure out a way they didn't have to comply with the injunction. So the judge is like, I see what you're doing, people, and came back and set it all out in a form that would be perfect for contempt. It could be taken into a contempt situation, or if for some reason this is appealed, which it could very well be, and if the Supreme Court got a hold of it. What are they going to do? Well, we don't know. This was just issued yesterday. The judge is saying I'm not going to reconsider it. I'm not going to stop the proceedings. So they have to comply with the requirements. Now, I think they still have a couple days left in order to conduct these interview of the 6 people in South Sudan, and then that all has to be on file. So in the last order he gave a deadline, and he's like, dude, you need to give us our stuff by then or you're going to be in trouble. Ooh, yeah, Marlene, oh my goodness gracious. So what will it take for the judge to take action? The judge is already there. We're probably at about 85% here. 85% contempt situation. He's found contempt. He's found violations of court orders repeatedly, intentional, in bad faith. And with a finding like that, the next piece that he gave was, how are you going to fix it, right? So he said, you committed violations of my order. You need to fix it. And I think it's the 29th, maybe. I can't remember the exact date, everyone, but there's just a couple more days. I think by Thursday of this week, you have to remedy it. And if you don't remedy it by the deadline, then we're going forward in contempt. Right. Actions or consequences. So each person involved in the situation could be charged with a criminal contempt. There's already a preliminary finding of the probable cause. There's no enforcement. Well, and Wise Owl, a lot of people ask that. There's no enforcement, right? Anybody who has the authority to enforce the laws has the authority to enforce a court order asking for the arrest and detainment of the DOJ attorneys, right? So let's just take a peek here at the people again, lest we forget. And again, I apologize for the filter, everyone here, but so this fella right here, who I had actually have been pulling lines out of his filings that are unethical. So this fella Yakov, he can be arrested. He can be arrested and he can be taken in front of the judge, and the judge can say, you need to go to jail. Right? That can happen there with Mr. Yakov. So with Mr. MacArthur, this fella here, all right, a warrant for his arrest. You go, you get him, you pick him up, and you bring him to court, and then he can go to jail. This one here, Mr. Hamilton, right here, this fella, arrest warrant, taken to the court, given jail time. That can also happen there with that particular one. And Mr. Ensign here. So this is the primary person, I think, in this situation. This Ensign person. So it would be an order for an arrest warrant. So the law enforcement person is commanded to go and hunt this guy down, pick him up, and bring him in for that. I know it's the filter. Sorry, everybody. All right, this Jonathan Guyuin person here also could be arrested and taken in if there's a finding of a contempt, and then the judge decides to offer a jail time. All right, so that's what would happen. That's the possibility of what would happen. Yeah, they can go to jail. So again, the thing to remember, and I know people are really frustrated. Actually, I think there is a bill, everyone. I cannot remember. I haven't read the bill, but there's a rumor on the Hill that there's a bill moving the jurisdiction or the command, I guess, of the marshals out of the executive branch in order to kind of give the courts more power. And I know the courts have been talking to each other about that as well, because a lot of people are saying, well, the U.S. Marshals are under the executive branch. True. But I want everyone to remember something that I think is just really, really important here. Really important. The U.S. Marshals take an oath to the Constitution. They take an oath to the country. They do not take an oath to a particular person. And that means they have to be in compliance with the Constitution. If they have an order from someone that would require them to violate the Constitution, that would be breaking their oath. All right. So we have to really remember that. Now, some people say, well, what about holding in on enforcement from the Attorney General? The Attorney General can do whatever she wants and say, enforce this, don't enforce that. That's fine. But the individual men and women who are the U.S. Marshals, each individual person will have to make that decision. Do I comply with the Constitution or not? And that's basically it. And a court order, there's nothing clearer than a court order saying, go pick up Mr. Yakov and bring him here to the bench. All right, we don't have a suspension of habeas corpus. We're not in a situation where, he can't be brought. He needs to go in front of the judge, and then the judge needs to make a determination about what's going on. All right. So with Mr. Yakov, again, I bring him up because he's kind of the leader of the pack. And then also Mr. Ensign here. This is the other fella presenting false information to a court. Yes, the filter's on. I apologize. I thought I had taken it off. So keep that in mind, everyone. Again, so, it might be like, well, we're part of the U.S. Marshal Services. And then that's the ultimate question, though, right? Is if your boss gives you an illegal order, right? So let's just take a minute. Let's step back even for a minute. All right. Let's say that the next higher up officer gives the order for a code red, but a code red's illegal. Are you going to comply and give the code red or not? Right? That's what this is about. This is a code red, everybody. This is a code red situation. The judge is like, go arrest this guy. All right? Right? Go arrest him. Oh my gosh. For those of you that may not remember, that's from A Few Good Men. You can't just do a code red on people. That's right. You have to comply with the court. And ultimately that's the court is the one, again, that is the last line in front of the Constitution. Would they be disbarred? It's possible they could be disbarred. All of these attorneys could be disbarred. Mr. Yakov in particular, oh, look at that, so pretty. So Mr. Yakov here is kind of whom I'm using to put together a series of posts going through and explaining the accountability out of the Department of Justice. There's a whole procedure, a whole process. When you have someone in the Department of Justice who is acting in bad faith, unethically, which again, I would even say this decision could be seen as evidence showing the dereliction of duty, the bad faith intent of Mr. Yakov. I would say this could be used as evidence, although he's got like probably a dozen filings where his comments and the things that he's saying are completely inappropriate. So that's completely wrong. This Yakov fellow was in the DOJ during Biden's term, right? So this is new. Each one of these people are, hand-picked from wherever their summoning circles were. So this isn't, a Biden situation here, which again, hashtag relevance, right? So I would say, again, I'm putting together a series to go through and explain how to file an ethics complaint, because if we have an issue with frivolous or lacking candor to the court, those are ethics violations. So I'll be putting that together at a later time. But I wanted to give you a visual here on our judge came in here, and the very first sentence, defendants have mischaracterized this court's order while at the same time manufacturing the very chaos they decry. So already has said, look, I know what you're doing. And it's not right. So we've got an ethics concern. Now, these kinds of ethical processes take a really, really long time to work through the whole process, but you still got to do it. You still got to do it. Why is the Ninth Amendment painfully ignored? Great question. Probably because it got all used up during the Dobbs case. That was a law burn. For anyone out there, it was a Ninth Amendment law burn. Sorry, I'm a dork. Ah. Yeah, I mean, I don't know. I don't know. I don't have the history of this guy. I don't know, but I do know he signed his name to some really, really atrocious filings that are absolutely the antithesis of our justice system. So, and that's kind of where we have our ethics problems. You can't just say stuff in your filings that completely undermines the judiciary. You can't do that without repercussions. So it takes time, and so it's going to take some time for this fella to be sorted out, along with all of these other fellas. It's going to take a little bit of time here. And this fella right here, again, is one of the big violators as well. So, but the point on this one is that this judge is already there. There's a couple of days left in order for them to cure the mistake that they made with violating the preliminary injunction. They've got a couple of days left. And if they don't remedy and they don't cure it, then, the plaintiffs, I would imagine, immediately would be filing show cause. So you have a show cause hearing. It's not going to take much work since it's already set out. We're already at 85%. Show cause hearing, and then boom. And then again, you say, well, what's going to happen after that? Well, then there's going to be some warrants. And, quite frankly, this fella right here with the eyebrows, he could be in court arguing that day. The court could be like, let's have a show cause hearing. And then at the end of the show cause hearing, the court's like, you've not shown cause why I shouldn't put you in jail. And so then, boom, you're going to jail now. You should be just escorted out of the courtroom and taken to the jail. Like, put your tie down, get rid of your pens, nothing sharp, no shoelaces, take off your jacket, where's your ID, let's go down to jail. So that could very well happen for all of the attorneys. I don't know who else is going to show up. This fella here too. Like, hey, you can't wear that pin when you're in the jail. Go ahead and take that off. We're going to be taking you down to the jail. No staples allowed. We know how it goes, right? That could be what's ordered at the end of the hearing itself. So we may not even need an arrest warrant. It's up to this judge. This judge isn't playing around anymore. I mean, it's just very, very clear. Look, bad faith. You did it on purpose. You were intending to do that on purpose. Okay, 5 p.m. tomorrow. Thank you so much, VC. I knew it was coming up. I wasn't exactly sure. Thank you. So there you go. Yeah, leave your eyelashes at home. Right? And I mean, I don't know the DC jail very well. Like, I don't know. Are they going to be put in the jail cell together? How big is the jail? Is it like a, spokes situation, or is it more of a pod situation? I don't know, but it's possible. But this fella right here, he just drives me bonkers. He just is so disrespectful to the whole system. I know we all want them taken into. I know it. But I have to say, out of all the cases, again, and I put this up before, everyone, we're on the cusp of contempt in multiple cases. The JGG case, which I think has a different name now. I think it's Sanchez, I think is the new name. Anyway, I'll get it for you all next time. But this is the DC case, right, where there's been a finding of probable cause for the violation. The Garcia case, this is the case where the Supreme Court's like, dudes, you know what? And then we have the DVD case, which is this one right here. So we're on the cusp. Now, don't get me wrong, there's about a dozen cases involving this whole situation, but those are the big three where contempt is definitely on the horizon. And again, that's just a look at the AEA habeas corpus deportation cases. That's not even the federal funding cases where they're on the cusp as well. An attorney can go to jail instead of client. Yes, and they should. and they absolutely should. Now, if an attorney's like, I refuse to tell you where my client is because I'm protecting them, or some kind of Tom Cruise moment, like old Tom Cruise, not new Tom Cruise, but like old school, right? Like, I'm here to save the country. That's one thing. But if you're like, well, I'm gonna just do whatever I want because everybody else is like doing whatever they want, no, you go to jail. You need to go to jail. Is what's gonna happen there. That's what's supposed to happen. If they are arrested, do the courts continue to try to get the people back? Yes. Oh yeah, we keep doing it. And see what's so great about contempt, right? Let's walk through that. So let's say tomorrow, 5 p.m. tomorrow, right? So tomorrow's Wednesday. They don't do it. So then he holds for cause hearing, all right? And he's like, fine, let's go to jail for 24 hours. You're like, oh, 24 hours isn't very much. True. Then he goes out and talks to the judge the next day. And he's like, okay, well, you have until 7 p.m. And they're like, well, no, it didn't happen. So you're going back to jail this time for 48 hours. Right? 2 days later, he comes out and he's like, all right, you need to get all of this done by 5 p.m. I'm going to give you 2 days to do it. And they're like, well, we're not going to do it. He's like, okay, now you're in jail for a week. So you can go back over and over because each time you fail to comply with the order is a new contempt situation. All right. So the first violation of you didn't remedy it, that's the first one. Go to jail. The second time, if the judge is like, well, all right, now you got a couple more days, go do it. And it doesn't happen, that's the next violation. So it just goes over and over and over again. What about the ones that are giving the orders to the attorney? Well, and I think that's a good point, all right, because we've got, let me see if I can get my picture here. I knew this question would come up, so I had a visual aid. Let me just make sure here. Come on, the visual aid out. Here we go. Here we go. I got the visual. Look at this. Right? So let's just take a look and see. So here we go. We got the people at the top, right? And what we're dealing with right here, we are in the district courts down here. So we're dealing with our U.S. attorneys, right? So these people are the ones going into court, right? But they're getting their orders from this fella, and that's that. Oh my gosh, I forgot his name again. I want to say Eminem, but that's not right either. What was his name? Bozeman? Well, whatever. This fella right here that was one of the criminal defense attorneys in the Stormy Daniels case, all right? This fella who answers to the, thank you, Bovee. I was close. I had an S instead of a V. Bovee. And so this is the Pam Bondi lady, Bad Faith Bondi, I think we decided, right? And so she tells him, and then he tells the U.S. attorneys, and then the U.S. attorneys do what they're going to do. But here's the deal. When it comes to attorneys, we're not like I'm going to go total dork here. We're not like the Borg. We don't have to just follow orders. This isn't military. This isn't, law enforcement. Attorneys notoriously will do whatever it is that they would like to do. So these U.S. attorneys here, they're not like, oh, I'm forced to do it. If I don't do it, something bad's going to happen. Are you freaking kidding me? No way. That's your choice. So they're making their individual choices. Now, the Bove up here, who's like, no matter what happens, you got to make sure that those people don't come back. He would be in violation too of that order if he's giving the order, but his role is different. All right. So his role is different. These people here knew that they were violating the order. But the thing is, the U.S. attorneys, these are their clients. So they're doing what their clients are telling them to do. So we've got two pieces. One, the attorneys are violating the order, and two, their clients know it's a violation of the order and are still going forward and saying, do it anyway. All right. So we've got several roads here. So their commanders or their clients could get into trouble, but the first line are going to be the attorneys, because these attorneys, everyone, should be following the rules. That's why 3/4 of the DOJ is gone, because they're like, we're not going to violate our ethics or the Constitution. That's why there's 5 attorneys left in the DOJ. Just these guys. These are the only guys left here. That's it. There's like two Erics, a Drew, a Jonathan, and then the Yakov fella. That's it. That's all that's left basically in the DOJ, because all of the other attorneys are like, we are not going to comply with illegal orders or unconstitutional, unethical orders. And so because we're not going to comply, we're leaving. And everybody like resigned and walked away. Like amazing, amazing litigators too. Some of these attorneys that, this was their career, and they were amazing, and they're like, we're out, man, we're out, because we just can't do that. That's what you're supposed to do. The ones that stay behind, or the new hirees, like this fella, that's bad business here. This is the bad business, the bad guys here. All right. So right, that's the ones that, yeah, those with integrity, exactly right. So this one's like, I'm gonna do whatever I want so that I can have, power. This is like the dark side, the Sith people, I guess. How many were there? I don't know. I do know there are approximately 350 U.S. attorneys in D.C., I think. That sounds right, assistant attorneys. But then, of course, you've got the list of the attorneys in charge of those divisions also. So, and those have been appointed. Some places haven't appointed anybody, but those are all, those can all be switched out and brought in. We've got that New Jersey situation going on in D.C. with, oh my gosh, Janine Garofalo, or she's, the yelling lady is like in charge of the DC place. The U.S. attorney in charge of that. Are you freaking kidding me? And then we have the other one. Thank you very much. Right, 94. And then we've got all the assistants. Shapiro. 94 U.S. attorneys. Yes. Porto. Janine Pirro, the Fox News lawyer. Right. You all know what I mean. And then we have the other person that didn't know what the rules of evidence were. I made a post for her because she was, in trial, and this was for the defamation case. Actually, she was representing in the defamation case. Multi-million-dollar verdict in that one, and she's like, I don't know how to get evidence into court, right? Right, Haba. Thank you, Name Vet. I appreciate that. It seems to me like you should know how to get evidence in if you're going to be a U.S. attorney. I just feel that way. Like, you don't have to all the time, but anyway, I don't mean to be judgy, but you should know what the rules of evidence are if you're going to be in charge of an entire division of U.S. attorneys, assistant attorneys. Do I fear being scandalized by Pam Bondi? I'm not sure what you mean by scandalized. Like, I'm not sure what you mean by that. Like, for me, every day seems like their first day. Well, before that. Be judgy. Oh, my gosh. Hey, Todd, they usually will give you a warning. And we're here to learn. This is not a debate area. So, just like, I can't help. Well, exactly. To have us submit evidence. I don't know. I really have no idea about that. Yeah, I'm not sure. There's a couple of things that I have done that I've put to the side that I have not spoken about because I don't want to get any flags. I'm trying to stay off the radar here. But typically I just move those over to the YouTube. But yeah, there's a couple of things that I wish I could have talked about, but could get me into a little bit of trouble. So I'm a little extra careful. Who aren't loyalists? Okay, yeah. Right. So what happens if these last few attorneys, that's a great point. That's a great question. Who knows? I really don't know. Because that's the thing is there is a finite number of attorneys in the U.S. And, if you have so many attorneys that are just, like, we're not going to do this, then what happens, right? I think that's a really good question. Right. Has anyone contacted you? Well, Right. This probably isn't the best place for me to disclose if I have or have not been contacted. I'll put it to you that way. How's that? There you go. Where does Rubio come into the case like Garcia when it comes to contempt? Good question. So Rubio is the one that could pave the road, right? Because it's the facilitating of the situation. So if he's not facilitating and he has the power to facilitate, now we're in contempt, right? Right. Right. State secrets. Got state secrets. How many attorneys they usually have? They've got a lot. Now again, and this is a good point too that somebody pulled out. We've got less than 100 actual U.S. attorneys that are at the top of the division, but underneath are their underlings, and those are the ones that really go in and do all of the hard work, in my opinion. So it's all of the assistant AGs that come in. For example, like here, this guy's a deputy assistant AG here, right? So they would be considered the assistants. They're not the actual U.S. attorney. They're considered deputy assistants. Yeah, and that seems right, VC. I think that's right for the attorneys. But then you have, the lower people further down the pyramid. Oh, thank you. Oh, that's so sweet of you. I wasn't sure today. I had a war wound here, which I should never say after Memorial Day, but I actually grabbed a box of nails. Weird. And I got a cut from a box of nails, everyone. Can you believe it? War wounds. Where's my work comp? What's the maximum that they can hold them for contempt? I'm not sure exactly at the federal level and which section they would pull that under. In my jurisdiction, you could get up to 30 days per count. So per violation of contempt, you could get up to 30 days in jail. So, I know, Jennifer. Oh, I know. I have a big bin and I just go and scavenge through it, right? Like you're looking for the best apple. Is I'm looking for the best nails, and so yikes, I'm gonna have to wear some gloves. Yes, they're press. Yes, they're press on, and it's all about the glue. You just got to have the right glue. This is the not sponsored, but this is the glue that I use, and this lasts really well. It's waterproof, and so yeah. Consecutive days if more than one contempt charge. Absolutely could be. It just is going to depend on what the judge wants to do. But again, each time, and to remember everybody, each time that they're not returned, and this is the same for Garcia, once that wheel starts turning faster, every single time the judge sets a date and time for the return and they're not there, that's another contempt charge. That's another one repeatedly. What if they fail to comply after a contempt violation? Can they be? Yes, repeatedly, over and over and over again, indefinitely. So every single time. Now the judges try to plan things out and work things out in a way. What they want is compliance. Like they don't want the attorneys in jail. They don't want any of that. What they want is the law to be followed. So what they will try to do is continue to go forward and negotiate. Usually attorneys that get tossed in for contempt will hire their own attorneys. And so then you've got attorneys on attorneys. And so they'll go and negotiate with the judge. Like, how can we do that? What can we do to take care of this? Because that's what the judge wants. That's it. I mean, the judge isn't trying to just be. Now, caveat. It's supposed to be that the judges aren't just trying to be jerks about stuff. I suppose there could always be situations that would be gaggles of attorneys. Yes. It's possible, Carol. It's a long process to debar an attorney, and it's all about intent. I would say we definitely have the intent elements that we would need in order to go forward in this particular case with a couple of these attorneys. Here's the glue again. Yeah. There you go. Not sponsored, everybody. Not sponsored. There you go. I'll just hold it there. Screenshot. There we go. Yes. So again, they can file multiple times with that. All right. With that, everybody. Oh my gosh, got the sirens going here. File multiple times with that. All right. With that, everybody. Oh my gosh, got the sirens going here. File multiple times with that. All right. With that, everybody. Oh my gosh, got the sirens going here. With that, I will go ahead and yeah, it's a huge, huge risk of our live for now. I am planning everyone to be back over on the tube. It is Tuesday, so we've got tube and Tuesdays tube for the tubes. I don't know. I will be back over on the tube tonight at 8 o'clock Central. Oh my gosh, and we've got some stuff to go over. I've got some paperwork to go over, everyone. Ooh, we've got some interesting things here. So 8 p.m. Central tonight, I will be over on the Tube of You. So come and join me here. And I will be going through several different orders. We'll kind of do a summary of the orders since there's just so much going on. I will be back again, though. I would like to do a live walking everybody through the process of calling these attorneys out as well. So that is also on my list. But with that, I will go ahead and sign off for our lunch and learn, everyone. Thanks for coming and hanging out with me. I would say absolutely this is the strongest, most heated of all of the orders that I've seen against the government so far when it comes to noncompliance. So no, you can subscribe for free over on the tube over there. There is an option if you want to kick it up a notch, but you certainly don't have to. So I will be over there 8 o'clock tonight, everyone, Central. So see you all then.